At my husband's funeral, his brother received an inheritance of $37 million. I was handed a crumpled envelope. When everyone left, I opened it. Inside was a phone number. When I called, I heard my husband's voice. "Darling, I'm alive. Listen carefully." Good day, dear listeners. It's Louisa again. I'm glad you're here with me. Please like this video and listen to my story till the end, and let me know which city you're listening from. That way I can see how far my story has traveled. My name is Margaret Eleanor Whitfield, and I was 67 years old the autumn I buried my husband and discovered that the man I had loved for 41 years had left me a crumpled envelope. Before I get to that, let me tell you about the life we had. Richard and I met at a county fair in Ohio in 1982. He was selling insurance and I was eating a corn dog, and he said I had the most sensible shoes he had ever seen on a woman. That was Richard's idea of a compliment. I married him 6 months later. We raised 2 daughters in a white house on Elm Creek Road, took every vacation in a minivan, argued about the thermostat for 4 decades, and built something quiet and solid together. The kind of marriage that doesn't look like much from the outside, but holds the weight of everything. Richard was a careful man, an accountant by training, a worrier by nature. He kept paper files when everyone else had gone digital. He wrote the PIN numbers of our accounts in a little notebook he hid inside a hollowed-out copy of the complete works of Mark Twain on the 3rd shelf of his study. I knew where it was. He knew I knew. That was trust. His younger brother Daniel was a different kind of man entirely. Daniel Whitfield was 59, charming in the way a used car salesman is charming. All surface shine and fast talk. He had borrowed money from Richard 3 times over the years and repaid it twice, and that last $8,000 had never been mentioned again, at least not in front of me. He called Richard every Sunday evening, which I had always thought was sweet. Now I wonder what exactly they were talking about all those years. The first sign that something was wrong came about 8 months before Richard died. He started being vague about money. Richard had never been vague about money in his life, but when I asked about our joint brokerage account, the one we had been adding to since 1994, he waved his hand and said it was being restructured. When I sat down to pay our property taxes in March and went looking for the quarterly statement, he said he would handle it. When I asked about the will, which we had both signed in 2009 and kept in the fireproof safe in the basement, he said he wanted to revisit it with a new attorney. "Why?" I asked. "Things change," he said. I remember standing at the kitchen sink, staring at the bird feeder in the backyard, feeling a cold thread of unease run through me. Richard had never spoken to me in vague non-answers, but he was also 68 and tired, and had been tired for a while. I told myself it was age. I told myself it was nothing. 3 months later, he was diagnosed with an aggressive form of pancreatic cancer. What followed was the landscape of caregiving. Hospitals, hospice consultations, medication schedules, the particular grief of watching a precise and capable man lose the ability to hold a pencil. Daniel visited often during those months, more than he ever had before. He would sit with Richard while I ran errands, help him with the computer, take him to appointments when I had a bad knee week. I was grateful. God help me, I was grateful. Richard died on a Tuesday in September, quietly, in our bedroom, with the window open and the sound of the neighbor's lawnmower in the distance. I held his hand. He didn't say anything in those last hours, not really. He squeezed my fingers once, hard. That was all. At the funeral, Daniel was everywhere, greeting people at the door, standing by the casket, accepting condolences as if he were a widower himself. I was too numb to register it as strange. After the service, the attorney, a man I had never met, who introduced himself as Gerald Holt, gathered us in a side room at the funeral home. He read the will. It was a new will, dated 7 months prior, around the time Richard had first started being vague. Under its terms, Richard's estate, including investment accounts, life insurance proceeds, and the sale value of our family home, totaled approximately $37.4 million. Richard had done well over a lifetime of careful investing. I had known we were comfortable. I had not known we were that comfortable. Every cent went to Daniel. Gerald Holt handed me an envelope as I sat there, still wearing my black dress, still holding a folded program with Richard's photograph on the front. The envelope was crumpled, slightly damp, as if it had been carried in someone's pocket for a long time. "Mr. Whitfield asked that you receive this," he said, and moved on. I sat in that room alone after everyone had filed out, and I opened it. Inside was a single index card with 10 digits written in Richard's handwriting. A phone number. I stared at it for a long time. Then I drove home. I sat in the driveway for 20 minutes. I walked inside, stood in the kitchen where we had eaten 40 years of breakfasts, and I dialed. It rang twice, and then I heard my husband's voice. "Margaret." A pause. "I'm alive, and I need you to listen very carefully to everything I'm about to tell you." I didn't speak. I couldn't. My hand was pressed so hard against the phone that my knuckles had gone white, and the only sound in that kitchen was the hum of the refrigerator and my husband's voice coming out of a speaker, like something from another world. "If you're hearing this," Richard said, "then I'm already gone, and Daniel has done exactly what I was afraid he would do." It was a recording. Of course it was a recording. Richard was dead. I had held his hand. I had watched them close the casket. But his voice was so clear, so present, so unmistakably him. The slight Ohio flatness, the way he always said Margaret and never Maggie. That my legs stopped working, and I sat down on the kitchen floor with my back against the cabinet where we kept the good dishes. "I made a terrible mistake," his voice continued. "I trusted Daniel with things I should have handled myself. About 18 months ago, I found out I was sick. Not the cancer, before that. A small stroke that the doctor said could lead to more. I was frightened and I wasn't thinking straight, and Daniel offered to help me update my estate plan. He said he knew a good attorney. He said it would protect us both." A pause. I could hear him breathing on the recording. The sound of it nearly destroyed me. By the time I understood what was happening, he had me sign documents I didn't fully review. I was confused, Margaret. More than I told you. I'm sorry. I tried to correct it. I hired my own attorney, a woman named Patricia Lamb in Columbus, and I gave her a package of documents, originals, evidence of what Daniel did, evidence of how the new will was procured. She has everything. Her number is written on the back of this card. I turned the index card over. There was a second number. "The will he put in front of Gerald Holt is not the real reflection of my wishes," Richard said. "You were supposed to have everything. The house, the accounts, all of it. What he did is called undue influence, and it's illegal. Patricia will explain. She's good. She's been waiting for your call." Then, "I love you, Margaret. I'm sorry it took me so long to be brave." The recording ended. I sat on that kitchen floor for a very long time. Let me tell you what 41 years of marriage feels like when it ends on a recording you play alone on a Tuesday night in September, in a kitchen that still smells like the man who is no longer in it. It feels like a building collapsing slowly, floor by floor, in total silence. I cried. I am not too proud to say that. I cried the way you cry when there is no one to hear you, which is to say completely and without dignity. And then, and this is the part I want you to understand, I stopped. I got up off the floor. I washed my face at the sink. I looked out at the dark yard where the bird feeder hung empty because I hadn't filled it in 3 weeks. And I thought about what I had actually lost. I had lost my husband. That loss was real and it was permanent, and nothing in the world was going to fix it. But I had not yet lost everything else. The house I had lived in for 34 years. Daniel was going to get it. The investment accounts Richard had built through 40 years of caution and discipline. The life insurance policy I hadn't even known the full value of. My retirement, my security, the money I would need for doctors and prescriptions and the years ahead of me. All of it. In a document signed by a man who was confused and frightened and manipulated by his own brother. Was I afraid? Yes. I was 67 years old, recently widowed, and sitting alone in a house that was apparently no longer legally mine. Of course I was afraid. But I was also a woman who had balanced a household budget, raised 2 daughters, and watched her husband die with my hand in his. And I had just been handed, on a crumpled index card, a path forward. I did not call Patricia Lamb that night. It was too late, and I needed to think clearly when I did. Instead, I did what Richard would have done. I got out a legal pad and I wrote down everything I knew, everything I had heard, and every question I needed answered. I wrote for 2 hours. By midnight, I had the outline of a plan. The first step was simple. In the morning, I would call Patricia Lamb. The second step would follow from whatever she told me. I would take this one move at a time, like Richard with his tax filings. Methodical, documented, patient. Daniel thought he had buried the truth along with my husband. He had forgotten that Richard trusted me with everything, including, it turned out, his last act of resistance. I called Patricia Lamb at 8 o'clock the following morning. She answered on the second ring, which told me she had been expecting the call. Her voice was steady and professional, the voice of someone who deals in difficult facts without flinching. She said she was sorry for my loss, and it sounded like she meant it. She said she had been holding Richard's materials since late spring, nearly 6 months, and that she was glad I had reached out. "Can you come to Columbus?" she asked. "I can come today," I said. I drove the 90 minutes with the index card in my coat pocket and Richard's legal pad on the passenger seat. Patricia Lamb's office was on the 4th floor of a brick building near the state courthouse. Not flashy, not shabby. The kind of office that belongs to someone who wins cases without making speeches about it. She was younger than I expected, mid-40s, with reading glasses pushed up on her forehead and a directness I respected immediately. She brought out a manila folder and set it on the table between us. "Your husband came to me in April," she said. He had already been diagnosed with the pancreatic cancer by then, and he believed he had, at most, a few months. He was concerned that a will revision he had signed the previous November was not legally valid. He described the circumstances under which he signed it. She opened the folder. What I saw inside changed everything from suspicion to certainty. There were 3 documents. The first was a handwritten statement from Richard, 4 pages in his careful accountant's print, describing how Daniel had introduced him to Gerald Holt in October of the prior year, framing the meeting as a routine estate update. Richard wrote that at the time, he had already suffered 2 minor strokes, neither of which he had disclosed to me, fearing I would worry, and that his short-term memory and judgment had been intermittently impaired. He wrote that Daniel had been present in the room during the signing, standing behind him, and that the meeting had lasted less than 20 minutes. The second document was a neurologist's report requested by Patricia, confirming that a person who had experienced the specific type of stroke Richard described would be at elevated risk for impaired decision-making and increased susceptibility to suggestion during the period in question. The third was a copy of Gerald Holt's bar registration with a handwritten note from Richard clipped to it. Daniel and Holt. Same golf club since 2018. Check. I sat with those 3 documents for a long time. "Can we win?" I asked. Patricia folded her hands. "Contesting a will is never simple, but the grounds here are solid, undue influence, and arguable lack of testamentary capacity at time of signing. The fact that Richard anticipated this challenge and documented it contemporaneously, in detail, is significant. The relationship between Holt and Daniel is significant. The medical record is significant. She paused. I'd put our chances at strong if we build the case properly and don't give Daniel time to prepare a counter-narrative. When do we file? I'd like 2 weeks to finalize the petition. The moment we file, he'll know. She was right about that. As it happened, Daniel found out even before we filed. 2 days after my meeting with Patricia, I received a call from Gerald Holt's office requesting that I come in to discuss the administrative transfer of the estate. I went. Patricia advised me to go and say nothing substantive, simply to observe. I sat across from Gerald Holt and listened to him explain the probate timeline in smooth, practiced sentences, and I asked 2 questions: whether the will had been witnessed by independent parties, and whether a copy of the original 2009 will was on file with his office. I watched his expression shift. Barely. Just a fractional tightening around the eyes. That evening, Daniel called me. Margaret. His voice was warm in the way it always was, that coating of warmth over something harder underneath. I just wanted to check on you. Gerald mentioned you stopped by. I did, I said. Just getting my bearings. Of course. Listen, I know this is a hard time. I want you to know I'm going to make sure you're taken care of. We're family. The word family landed in the room between me and the phone, like a stone dropped in still water. I appreciate that, Daniel, I said. After I hung up, I sat very still. He was watching me now. He had heard something in those 2 questions I'd asked Holt, or Holt had reported back to him immediately. Either way, the comfortable window of invisibility I had briefly enjoyed was closing. Good. That meant I needed to stop being cautious and start being fast. I called Patricia that night and told her we needed to move up the timeline. File as soon as you can, I said. I want this on record before he has time to move anything. She filed 10 days later. There was no going back. Patricia called me the morning after she filed to tell me the petition had been accepted and that Daniel's attorney, a man named Clifford Bray, who apparently charged $600 an hour and appeared regularly in probate disputes in Franklin County, had already made contact. That was fast, I said. That means he was prepared, she said. He expected this, or something like it. She didn't sound alarmed, which helped me stay calm. She said Clifford Bray had called to make it clear that his client intended to defend the will vigorously, that they had witnesses who could testify to Richard's clear mental state at the time of signing, and that any attempt to drag out the probate process would only result in additional legal costs for both sides. A politely delivered threat dressed in legal language. Patricia said we would respond formally through the proper channels. Daniel didn't wait for proper channels. He called me himself that same afternoon. I was in the living room, sitting in Richard's chair because it still held the shape of him, and some days that was all I had. And my phone rang, and there was Daniel's name on the screen. I let it ring once. Then I answered. I just got off the phone with Cliff, he said. The warmth was gone from his voice entirely. This was a different register, still controlled, but stripped of the performance. I want to know what you think you're doing. I'm contesting the will, I said. I think you know why. A pause. Margaret, Richard was clear about his wishes. I know it's painful. I know you feel... Richard left me a recording, I said, and documentation. I know about the strokes. I know about Gerald Holt. I know about the golf club. The silence that followed was the most informative thing Daniel had said to me in years. That's a very serious accusation, he said finally. Yes, I said. It is. I would encourage you to think very carefully before you pursue this. His voice had taken on a quality I can only describe as cold. Cliff tells me that anyone contesting a will of this complexity at your age, with your, he paused deliberately, circumstances, could face a long and extremely expensive process. And there are questions that might be raised about whether you were involved in Richard's estate planning decisions all along, whether your influence on him goes back further than people realize. He was threatening to make me the villain. I had expected something like this. Patricia had warned me it might happen. Even so, sitting in Richard's chair, in Richard's living room, in a house that was supposedly no longer mine, hearing my brother-in-law imply that I had manipulated my own husband, it took everything I had to keep my voice level. "I'll see you in court, Daniel," I said, and ended the call. I sat there for a while, shaking slightly. The kind of shaking that isn't fear exactly, but is the body's response to having stood its ground against something that wanted to knock it over. 2 days later, Daniel showed up at the house. I saw his car from the upstairs window, that silver Mercedes, always freshly washed, and I called Patricia before I went downstairs. She said, "Don't engage. Don't let him inside. Say nothing about the case. Call her immediately if he became threatening." I stood at the front door with my phone in my hand, and I opened it. He was standing on my porch in a gray coat, and he looked, for just a moment, like he had come with regret in his posture, something almost like shame. But his eyes were hard and quick, scanning the hallway behind me. "I think we should talk," he said. "Our attorneys are talking," I said. "That's sufficient for now." He stood there for another moment, looking at me the way a man looks at something that has surprised him by not moving out of his way. Then he turned and walked back to the Mercedes. I closed the door and locked it. I called Patricia and told her about the visit. She documented it. She said it was possible it would be relevant later, showing a pattern of direct pressure. After that, I gave myself 3 days. I didn't call anyone. I didn't read case documents. I refilled the bird feeder that had been empty since before Richard died, and I watched the sparrows for an hour one morning with a cup of coffee. And I let myself cry once, properly, and then I slept for 9 hours, which I hadn't done since the diagnosis. When I came back to the desk on the 4th morning with fresh eyes and a steadier heart, I was ready for the next move. Daniel had shown me exactly how frightened he was. Frightened people make mistakes. I was counting on it. The settlement offer arrived on a Wednesday. Patricia called me in the early afternoon and read it aloud in a neutral, professional tone that I had come to understand meant she personally found something contemptible. Clifford Bray, on behalf of Daniel Whitfield, was offering a one-time payment of $180,000 to Margaret Whitfield in exchange for the immediate and unconditional withdrawal of the will contest petition, a signed non-disclosure agreement, and a formal statement acknowledging the validity of the November will. $180,000, I repeated. Yes. Out of $37 million? Yes. I looked out the window at the bird feeder. Tell him no. Patricia allowed herself a small sound that might have been satisfaction. I'll prepare the formal response. I didn't tell Patricia about Susan's call that came 2 days later, not immediately. I wanted to sit with it first. Susan Whitfield, Daniel's wife of 22 years, was not someone I had ever disliked. She was pleasant and careful, and kept her house very clean, and she had always struck me as a woman who knew exactly what her husband was, but had decided long ago that it was more comfortable to look sideways than straight at anything. She called me on a Friday evening, which was deliberate timing. End of the week, when a grieving woman might be at her lowest. "Margaret, honey." Her voice was soft and warm. "I've been thinking about you so much. I'm sorry I haven't reached out sooner. This whole thing has just been so painful for all of us." "I'm sure," I said. "I know there's all this legal business going on, and I just..." I hate it. I hate what it's doing to this family. Richard would have hated it. A pause, perfectly timed. He loved you both so much. He loved this family. Do you think this is really what he would have wanted? This fighting? There it was. I want you to understand something about that question, because it's a sophisticated weapon. It takes a grieving person's love for the deceased and turns it against their own interests. It says, if you loved him, you would stop. It implies that the very act of fighting for what is right is a form of disrespect to the dead. I had thought about this enough in the previous weeks that I could hear the mechanism of it clearly. Susan, I said, Richard is the one who asked me to make this call. His voice, his handwriting, his attorney. So I think I have a reasonable sense of what he would have wanted. Another pause. Longer this time. We just want this to be over peacefully, she said, and the warmth had thinned somewhat. I'm sure you do, I said. I hope it will be. I ended the call and sat very still in the kitchen for a while. My daughter Claire arrived the following Saturday with 2 bags and a pot of her lentil soup that she reheated without asking me if I wanted any, because she knows me well enough to understand that I will say I'm not hungry even when I am. Claire is 43, practical, with her father's eyes and my stubbornness, and when I had called her the week after the funeral and told her, carefully, not everything at once, what was happening, she had gone quiet in the specific way she gets when she is processing something serious. Now she sat across from me at the kitchen table, and I told her everything, all of it. Richard's recording, Patricia's assessment, the filing, Daniel on the porch, Susan's phone call. Claire listened without interrupting, which is something she has always been able to do. When I finished, she said, Mom, do you know what undue influence cases usually need to get traction? Publicity. I'm not interested in giving interviews, I said. I'm not talking about a press conference. She turned her phone toward me. I went to school with Ruth Alderman. She's a journalist now, local investigative, does probate and elder financial abuse cases. She's broken 3 stories in the last 2 years that went statewide. She's discreet and she's thorough, and she said she would talk to you. I looked at the name on Claire's phone screen. Talking to a journalist before the case is resolved, I started. Patricia would tell you not to comment on the case itself, Claire said. But you don't have to. Ruth isn't looking for a quote. She's looking for a pattern. She thinks Daniel's attorney, Clifford Bray, has been involved in at least 2 other similar estate cases in the past 4 years. I sat with that for a moment. A pattern. Not just my case, but a method. A repeatable scheme. Richard's golf club note suddenly felt heavier, more significant. Set up the meeting, I said. We met Ruth Alderman at a coffee shop in Columbus the following Tuesday. She was quiet and precise, asked careful questions, took no notes in front of me, but I suspected she remembered everything. She asked about Holt, about Bray, about the timeline of Richard's stroke and the introduction to the new attorney. She didn't promise anything. But she said, if what you're describing is accurate, you're not the first. Sitting in that coffee shop, with Claire next to me and a journalist across from me who had broken cases like mine before, I felt something I hadn't felt in weeks, less alone. It wasn't the same as safety, but it was something to stand on. It was a Sunday afternoon in late November when they came. I heard the car in the driveway and looked out the window and saw them both. Daniel in his gray coat and Susan carrying a covered dish, the 2 of them moving up the front walk with the practiced ease of people performing an act of goodwill. They had not called ahead. I recognized that as a tactical choice. It's harder to prepare when there's no warning. A person without warning reaches for courtesy instead of armor, and courtesy was exactly what they were counting on. I called Claire, who was upstairs reading. They're here, I said quietly. Both of them. Do you want me to come down? Not yet, I said, but stay close. I opened the door before Daniel could knock. Margaret. He had the warmth back, softer than before. The version he'd used in the months before the funeral, when I had thought he was simply a devoted brother. Susan stepped forward and pressed the dish into my hands. Shepherd's pie, still warm, a home-cooked meal, the universal language of people who wish to appear harmless. I set it on the counter and put the kettle on, without asking if they wanted tea, because that put me in control of something, and I needed that. We sat at the kitchen table. For the first 10 minutes, they were kind. They talked about Richard, a story from Daniel's childhood, a summer they had spent at their parents' lake house, the particular way Richard laughed at his own jokes before he finished telling them. I listened. I let myself feel the small, genuine grief in it, because Richard had loved his brother once, or had loved the idea of him, and that was real, even if the rest of this was performance. Susan mentioned the funeral, how beautiful the flowers had been, how many people had come. She said Richard had been so well loved. She was not wrong about that. Then Daniel set his mug down. Margaret, he said, with a particular gentleness that I recognized as the tone a person uses when they are about to say something they want to appear reluctant to say. I'm worried about you. I want to be honest with you. Please, I said. I think you've been given some very bad advice. I think there are people around you right now who see an opportunity in your grief, in this estate, and they're using it. An attorney who takes cases on contingency has a financial interest in prolonging litigation. A journalist. He paused, and his eyes were very still. A journalist asking questions about your family's private finances has her own agenda. That's not support, Margaret. That's exploitation. He knew about Ruth. I kept my face neutral. He had resources. Probably Bray had resources. And finding out that a journalist had been making inquiries wasn't difficult if you knew where to look. The fact that he mentioned it told me he wanted me to know he was watching. That was its own kind of pressure. The awareness of being observed by someone with the means to act on what they saw. I appreciate your concern, I said. Richard left things the way he did for reasons, Daniel continued. He was a thoughtful man. He wasn't confused. The idea that I would... He stopped, produced an expression of pain that was quite convincing. The furrowed brow, the slight downward press of his lips. The performance of a man who has been wounded by an unfair accusation. We were brothers. I was with him at the end. I helped him. I drove him to appointments when you couldn't. And now I'm sitting here in his kitchen being accused of... I haven't accused you of anything, I said. I've filed a legal petition. That's a different thing. Susan reached across and put her hand over mine. Her hand was warm and her grip was gentle, the physical language of a woman offering comfort, and I understood exactly how much calculation had gone into that gesture. We just want to help you, sweetheart. This process, it's going to take years. It's going to cost you money you don't have right now. It's going to be exhausting in public, and by the end of it... She paused. Let the silence do work. Judges are not always sympathetic to these claims. We've been advised that a certain amount of confusion in the elderly is considered normal and doesn't necessarily... She stopped herself, but not fast enough. The elderly, I said. The word sat in the kitchen between us, like something that had been dropped and couldn't be picked back up. She had the grace to look briefly uncomfortable. I just meant... I know what you meant, I said. I stood up. What she had nearly said, that my confusion was a natural product of age, and therefore the will that stripped me of everything should stand, was not a slip. It was a preview of their legal strategy, offered here in my kitchen as a warning dressed in concern. They wanted me to understand what they were prepared to argue in front of a judge, that I was old, that I was grieving, that I was being led by a self-interested attorney, and that none of it, not the recording, not the documents, not Richard's own handwriting, was as reliable as a woman my age believed it to be. "I think we've covered the ground we needed to cover today," I said, with a steadiness that surprised even me. "I appreciate the shepherd's pie. I'll see you out." Daniel's composure slipped just slightly, a tightening of the jaw, the smallest recalibration of his expression from concerned brother-in-law to something colder and more honest. He stood. Susan gathered her coat with hands that moved a little too quickly. At the door, Daniel paused and looked at me one last time, and there was no performance left in his face at all. "Think carefully, Margaret," he said, "about what you're doing and who you're protecting, and whether any of this is worth it." He left. I closed the door and locked it. I stood in the hallway, and for a moment, I will not pretend otherwise, I was frightened. Not the sharp fear of an immediate threat, but the slower, heavier kind. The fear of being out-resourced, outlasted, outmaneuvered by people who had been planning longer than I had. The case was not resolved. I was in a house that was legally contested. I was 67 years old, and a man with $600 an hour representation had just implied in my own kitchen that age itself was a vulnerability I couldn't overcome. But then I thought about Susan's slip, about the word elderly hanging in the air before she caught it. She had handed me something without meaning to. Their strategy was not just to defend the will, it was to undermine me as a witness to my own life, to make the court see a confused old woman instead of a wife who knew her husband completely. That required them to dismiss not just the legal evidence, but me personally, my memory, my judgment, my grief itself recast as distortion. They wanted me to feel small so that I would act small. I went upstairs and told Claire what had happened. She listened, and then she said, "They're scared." "I know," I said, and there it was. The fear in that hallway, turning over slowly, becoming something else entirely. Becoming the particular kind of resolve that comes not from certainty about winning, but from the absolute refusal to be the person they needed me to be. The hearing was scheduled for a Monday in February, 4.5 months after Richard's funeral. The night before, I slept 6 hours, which was more than I expected. I laid out my clothes, a navy dress, the kind Richard always said made me look like I knew what I was doing, and I drank 1 glass of water, and I read, for the last time, every document in the folder Patricia had given me. Not because I had forgotten anything, because I wanted Richard's handwriting fresh in my mind when I walked into that room. I wanted to feel the weight of what he had left me. Not money, but evidence. Not an inheritance, but an argument. His last careful act. I also, before I slept, thought about what it would mean to lose. I allowed myself that. Not to dwell in it, but to look at it honestly, the way Richard looked at a tax filing. Find the worst number first, understand it fully, then build from there. If we lost, the estate would remain with Daniel. I would have the house for the duration of any ongoing legal process, but eventually I would lose that too. I would have a foundation to try to rebuild from. Social Security, some personal savings outside the estate, Claire's help. I would not be destitute, but I would have lost what Richard intended me to have, and I would have to live with knowing that Daniel had succeeded and that the system had permitted it. I looked at that possibility directly, and then I set it aside. The courthouse was a gray stone building on High Street that smelled like every courthouse I have ever entered. Old paper and radiator heat, and the particular institutional quiet of a place where serious decisions are made in procedural language. Patricia met me in the lobby wearing a dark suit with her reading glasses already on her head, and she looked at me with the direct assessment of someone checking the structural integrity of something she had built. "How are you?" she asked. Ready? I said. And I was. The hearing was before the Honorable Sandra Okafor, a probate judge I had not met and had only read about. And what I had read suggested she was methodical, unimpressed by theatrics, and known for asking very precise questions at exactly the moments an attorney hoped she wouldn't. I took that as a good sign. I don't trust judges who perform sympathy. I trust judges who are rigorous. Daniel and Susan sat on the other side of the aisle with Clifford Bray between them. Daniel was wearing a dark suit and the face he wore to funerals. Grave, composed, subtly aggrieved. He glanced at me once when I came in, a single measuring look, and then directed his attention forward and did not look at me again. Susan sat with her hands folded and her eyes slightly downcast. They were very good at this. Patricia presented her case in the order of a careful argument, building from foundation to structure to detail. She began with Richard's medical history. The 2 strokes documented, the attending physician's records, the neurologist's expert testimony about the effects of that specific kind of cerebrovascular event on a patient's capacity for independent decision-making and resistance to persuasion. The neurologist was a woman from Ohio State University Medical Center who spoke without simplifying her language, and I noticed that Judge Okafor took more notes during this testimony than during anything else in the morning session. That told me something about what the judge considered the central question. Then Patricia entered Richard's handwritten statement into the record. She read portions of it aloud. I had read that document many times. I thought I had insulated myself against it. But hearing it read in that room, in a formal proceeding, with Richard's words given the weight of legal evidence, I was frightened, and I wasn't thinking straight, and Daniel offered to help me. I had to press my hands flat against my thighs and look at a fixed point on the wall to keep my composure. This was not the place to grieve. I would grieve later. Here, I needed to be exactly what they had tried to tell me I wasn't capable of being: precise, present, credible. I watched Judge Okafor's face as Patricia read the passage about Daniel standing behind Richard's chair during the signing, and Richard writing that he had felt unable to ask him to leave. The judge's face was a disciplined face, but there was a quality of attention in it, a sharpening, that I recognized as the look of someone who has heard something that confirmed a question they had already been forming. The golf club documentation came next. Patricia had obtained membership records. Richard's note had been correct. Holt and Daniel had joined within 6 months of each other in 2018, attended numerous events together, and Holt had referred 3 clients to Daniel's financial consulting firm over the following 4 years. A relationship, a documented, financially beneficial relationship between the attorney who drew up the contested will and the man who stood to receive everything under it. Clifford Bray objected twice during this section. Judge Okafor overruled both objections. Bray's cross-examination of me lasted 40 minutes. He was good. I will give him that. He was methodical in a different register from Patricia. He built questions that circled back on themselves, looking for inconsistencies, trying to establish that I had been the one managing Richard's affairs, and therefore the one with influence over him. He asked whether I had handled the household finances, whether I had accompanied Richard to medical appointments and therefore had information about his condition that I could have used to construct a narrative, whether Patricia Lamb had contacted me or I had contacted her. He was attempting to invert the story entirely. Not Daniel manipulating Richard, but Margaret, guided by a financially motivated attorney, manufacturing a false account of confusion and exploitation. He asked me whether I had prior knowledge of the recording before the funeral. No, I said. Whether I had encouraged Richard to work with Patricia Lamb. I didn't know Patricia Lamb existed until the evening of the funeral, I said. Whether I could explain why, if Richard had genuine concerns, he hadn't simply told me himself while he was still alive. I looked at Bray carefully. I had thought about this question. I had thought about it at 3 in the morning more than once. He was dying, I said. He was a proud and private man who had already not told me about 2 strokes because he didn't want to frighten me, and who spent the last months of his life trying to correct a mistake he was ashamed of. He did what he could with the time and clarity he had left. The recording and the documents he left with Patricia are evidence of exactly how much effort he put into that. I think the more useful question is why a man who spent 40 years being meticulous about his finances would choose, at the very end of his life, to leave everything to a brother who still owed him money. The room was quiet for a moment. Judge Okafor wrote something. Then Daniel took the stand. Patricia was different with him than she had been with the expert witnesses. Quieter, more patient, as if she were taking a long walk toward something specific and had no interest in rushing the arrival. She established the relationship with Holt, calmly, factually, without drama. She asked about the golf club. He confirmed it. She asked about the referral arrangements. He said he wasn't aware of any formal arrangement, which was careful language. She asked about the October meeting when the will was signed. Were you present in the room for the duration of the signing? Yes, he said. At whose request? Richard asked me to be there. He wanted family present. And at any point during that meeting, did your brother ask you to leave the room? No. Did you offer him the opportunity to review the documents privately without you present? A pause. I believe I offered. He said he wanted me there. You believe you offered? Yes. Patricia nodded slowly. She let the silence sit between them for a full 3 seconds, long enough to be felt in the room. Then she said, Mr. Whitfield, I'd like to direct your attention to Exhibit 14. The clerk put it on the screen. 1 page from Gerald Holt's own internal file notes, obtained during discovery. Handwritten. A single line, 3/4 down the page. Client expressed some hesitation. DB encouraged him to proceed. The room was very still. DB, Patricia said quietly, based on the context of this file, the names involved, the date, the matter at hand, who would you say those initials refer to? Daniel looked at Clifford Bray. Bray's face was controlled, but the stillness in it was the stillness of a man who had known this document existed and had hoped it would land differently than it was landing. Daniel looked back at the exhibit on the screen. His jaw had tightened. The architecture of composure, the careful, grieved, reasonable face he had maintained through the entire morning, began to show its seams. It could refer to anyone, he said. Those are common initials. Your full name is Daniel Brent Whitfield, Patricia said. Your middle name is Brent. He said nothing. The note was written by Gerald Holt, on the date your brother signed the contested will, in a file that contains no other individual with those initials. She looked at him for a moment. Did you encourage your brother to proceed with the signing when he expressed hesitation? Daniel opened his mouth, closed it. I was supporting him, he said finally. He was scared. I was trying to help him. Help him do what, specifically? Another silence. Longer this time. And in that silence, something finally gave way. Not loudly, not dramatically, but in the particular way a careful structure fails when the central support is removed. I watched it happen in his face, and I felt nothing triumphant about it. Only the quiet, factual recognition that the truth had simply become more visible than the story built to obscure it. No further questions, Patricia said. Judge Okafor issued her ruling 3 weeks after the hearing. Patricia called me on a Thursday morning in early March, and I knew from the first syllable of her voice that it was over. She set aside the November will, Patricia said. I sat down. On what grounds? I asked, though I knew. I needed to hear it formally. Undue influence and lack of testamentary capacity at time of execution. The judge cited the medical record, the relationship between Holt and Daniel, Holt's own file notation, and Richard's contemporaneous written account as collectively sufficient to establish that the November will did not represent Richard's free and informed expression of his wishes. I put the phone down on the table for a moment and looked at the ceiling. Outside, a bird was at the feeder. A small gray one, a junco, the kind that comes through in winter and is perfectly ordinary and entirely unremarkable and alive. "What happens now?" I asked. "The 2009 will is reinstated. Richard's original estate plan governs. The estate goes to you in its entirety, as he originally intended. $37 million. The accounts, the life insurance, the house that had always been mine and was now legally mine again. It took some time for that to feel real, and in some ways it still didn't. Money has always seemed to me like a symbol of something else, and what I had actually won was something that couldn't be numbered. I had won the truth of what Richard had wanted. I had stood in the space where he couldn't stand anymore, and I had held it. And Daniel?" I asked. Patricia's tone became more precise. "The ruling has been reported to the Ohio State Bar Association with respect to Gerald Holt's conduct. Specifically, the conflict of interest, the failure to ensure independent representation, and the file notation regarding Daniel's intervention during signing. A formal inquiry has been opened. Holt has suspended his practice pending the outcome." "And Clifford Bray?" "The referral pattern between Holt and Bray, 3 clients whose estates were subsequently contested, has been flagged for separate review by the bar. Nothing formal yet, but it's on record." She paused. "Daniel will likely appeal," she said. "I want you to be prepared for that." "Let him," I said. He did appeal. His filing came 5 weeks later, a dense legal document that Clifford Bray apparently spent considerable effort constructing, arguing that the probate court had given insufficient weight to witness testimony supporting Richard's mental clarity, and that the documentary evidence was circumstantial. The appeals court rejected it in under 30 days. I was told later that the panel had found the ruling well-reasoned and the evidence substantial. They used the phrase well-reasoned twice, which I thought Richard would have appreciated. The financial transfer was not immediate. These things move through institutions and accounts and legal formalities, and Patricia managed all of it with the same methodical precision she brought to everything. But by the time the spring came in fully, the house was unambiguously mine, the accounts were in order, and the life Richard had built over 40 years had been returned to the hands he intended it to go to. Ruth Alderman published her article in April. She had done exactly what she said she would. Built the pattern, documented 3 other estates involving Holt, identified the network of referrals, named names carefully and on record. She did not quote me extensively. She quoted Patricia twice. The headline was measured and factual. Elder Financial Abuse in Probate, a Pattern of Exploitation in Central Ohio. It was picked up by 2 state papers and 1 national outlet. Gerald Holt's bar inquiry concluded 8 months later with a formal finding of professional misconduct. His license was suspended for 2 years, with reinstatement conditional on demonstrated reform of practice. Clifford Bray's situation evolved more slowly, as these things do, but Patricia kept me informed. By the end of the year, 2 of the 3 flagged cases had resulted in family members filing their own petitions, both citing Ruth's article and the Whitfield case as precedent. Daniel's appeal failed. His attorney was under review. The social circle that had known him as a successful businessman with his brother's trust began to hear other things. I do not take pleasure in cataloging someone's downfall, even someone who did what he did. But I will say this. The structure of the life he had built on an accelerated timeline, the life he had been preparing to buy with my husband's estate, began piece by piece to become unavailable to him. The last legal document connected to the case arrived in my mailbox on a Thursday afternoon in April, a full 7 months after the hearing. I signed it, walked to my car, and sat there for a minute in the warm spring air. Then I went home and made dinner. A year and a half passed between the morning I sat on the kitchen floor listening to Richard's voice and the morning I drove to Columbus simply to have coffee with Patricia, with no legal matter between us. I stayed in the house on Elm Creek Road. People expected me to sell it, to move somewhere smaller, somewhere without the weight of 41 years in the walls. But the weight didn't feel like grief anymore. It felt like accumulation. The reasonable mass of a life lived in a place where things mattered. I had the kitchen repainted, a very pale green, the color of the inside of a pear. Richard would have found it peculiar and eventually come to love it. I established a small foundation focused on legal support for elderly individuals facing estate challenges without resources. In its first year, it helped 11 families. 7.1. I don't consider this legacy building. I consider it something Richard would have done if he had more time. Claire comes most Sundays, sometimes with my granddaughter, who has recently become interested in birds. Ellen visited for 2 weeks that first summer and didn't offer her opinion on my decisions, which I appreciated. She understood I didn't need to be saved, only accompanied. Ruth's article became part of a broader state inquiry into elder financial exploitation. A bill was introduced requiring independent legal counsel for cognitively vulnerable individuals during estate modifications. Patricia testified. I submitted a written statement. And Daniel. He did not go to prison. Civil law doesn't work that way. What he lost was the estate, and then the reputation. Slowly, then quickly. His firm lost clients. The life he had been preparing to buy with my husband's money became unavailable to him, piece by piece. I don't feel triumph about this. I feel something quieter. The settled sense of a correct equation. That deception requires constant maintenance, that the truth does not. Richard knew this. He spent his last months documenting it with the care of a man who believed patience and precision were the most powerful tools available to anyone. He was right. On the anniversary of his death, I sat in his chair and listened to the recording one more time. Not as evidence, because I wanted to hear him say my name once more. Margaret. After it ended, I refilled the bird feeder, made tea, and watched the yard come into the morning light. I am 68 years old. I am still here. The life I am living is the life I was supposed to have. That felt like enough. I learned this. Grief makes you vulnerable, but it doesn't have to make you passive. The people who exploit loss depend on your silence, your exhaustion, your willingness to believe that fighting back costs more than giving in. It doesn't. Richard gave me the last gift he could, not money, but a path back to the truth. I took it. That's all I did. If someone you loved left you a recording and a phone number, what would you do? If this story moved you, leave a comment and subscribe. It means more than you know. Thank you for listening.